Today we're discussing the topic of warrantless surveillance under Section 702 of FISA and SAR, Suspicious Activity Reporting. And before I get into today's topic, I want to share with all of my new viewers and all of my subscribers why I'm so passionate on this topic and why I feel I'm a credible voice to speak out on this platform against this targeted harassment. Now I'm gonna take you to an article on the Mortgage Fraud blog, and I'm gonna leave a link. Some people are gonna pass judgment, but some can learn from my experience and my situation. And in this blog, this goes in how the Secret Service investigated my cousin and basically indicted him on mortgage fraud. Now check out the article. The case against Boeing, Sellers, Love, and 7 others was based on an investigation by the Internal Revenue Service, Criminal Investigation Division, and the U.S. Secret Service, which indicated that from May 2002 through May 2007, the defendants conspired to commit mortgage fraud in Phoenix, San Diego, and Las Vegas. So from 2002 through May 2007, I was also under investigation, even though I was not involved in this mortgage fraud scheme and I didn't know anything about it. And out of 5 years of investigating me and following me and trying to sabotage my life, they know this. So, and the bullshit continues. That's why I'm making these videos, because why is it that even after the investigation was completed, I'm still being investigated? So, well, I'm going to get into why all that is. So I just want to scroll down to the very bottom. The investigation in this case was conducted by the Internal Revenue Service Criminal Investigation Division, the U.S. Secret Service, and Office of Inspector General Social Security Administration. See, I told you all these federal agencies link up together and they come at you with the Patriot Act. So here's in Section 506, when they extended the Secret Service jurisdiction to encompass any fraud or other criminal or unlawful activity in or against any federally insured financial institution, like a bank. So that's pretty much how I got caught up in all of this because of someone else, though. But this is how. So check it out on the warrantless surveillance under Section 702 of FISA. How they could keep it going, because under Section 702 of the Foreign Intelligence Surveillance Act, FISA, the U.S. government engages in mass warrantless surveillance of Americans and foreigners, phone calls, text messages, emails, and other electronic communications. Information collected under the law without a warrant can be used to prosecute and imprison people, even for crimes that have nothing to do with national security. Given our nation's history of abusing its surveillance authorities and the secrecy surrounding the program, we should be concerned that Section 702 is and will be used disproportionately target disfavored groups, whether minority communities, political activists, or even journalists. So the culprit, it seems to me, is Section 702 in this whole FISA. Section 702 is set to expire at the end of this is an old article because they just renewed it and it's good to 2023. So what's wrong with Section 702? So now let's get into some facts. I'm going to leave this link. This is on the ACLU website. Section 702 allows warrantless surveillance of people inside and outside of the United States. Though Section 702 is justified as counterterrorism tool, in reality it permits surveillance far beyond what is needed to protect national security. It allows the government to target foreigners abroad if it believes they possess foreign intelligence information, a term so broadly defined that it can include ordinary information about foreign affairs that have nothing to do with national security. This means that targets of surveillance could include human rights defenders, journalists, whistleblowers, or business owners. The government collects the personal information of these individuals, including any communication they may have with people in the U.S., and stores it in a database for years, and in some cases indefinitely. That's why I've been over stressing. It doesn't matter if it's a criminal case or no case. They're storing your information. They're having you under surveillance, period, point blank. Number 2, despite the fact that the law is not supposed to be used to target Americans, the government has been doing just that for years. Once the government collects vast amounts of information, including emails, text messages, and other communications under Section 702, that content is stored in a database for years at a time. FBI, CIA, and NSA, like I've been saying, routinely search through the vast trove of data and information specifically about Americans, even though these communications were all collected without a warrant. Information found through these backdoor searches can be used to prosecute Americans for crimes, even if they are not related to national security. And once we get into the SAR, suspicious activity reporting, you're gonna see how it don't have to be a criminal activity for you to be under surveillance. Information collected under 702 could be used against you, and you likely wouldn't know. The government can use information collected under 702 in a wide variety of contexts, from criminal cases to immigration proceedings, despite the government being legally required to provide notice to defendants when information collected under Section 702 is to be used against them. In only a handful of cases has this notification ever been provided. Section 702 is used to examine communications following in and out of the U.S. in bulk. Number 5, surveillance programs have been abused by the intelligence agencies. Let's check that one out. The NSA admitted in 2013 that the analysts, in a number of instances, improperly used surveillance databases to monitor their access in a practice known by some as LOVEINT. I don't know exactly how to pronounce that, but trip off the wording. Analysts, those are the surveyors, the crime analysts. If you check out some of my other videos, you'll see about the stakeholders. One of them is a crime analyst. So anyways, additionally, a recent opinion from the Foreign Intelligence Surveillance Court regarding Section 702 surveillance revealed a significant number of other violations that raised significant Fourth Amendment concerns and were not properly disclosed to the court. And you can find this video if you type in some of these key wordings. The NSA violations were so significant that the NSA even ended some of its surveillance practices, though it could restart them at any time. There is little that prevents Section 702 from being used against critics, activists, religious minorities, or communities of color. But remember, they're not supposed to target people that are under the First Amendment according to the Patriot Act. I'm not going to reference it, but it's written. Our government has a history of using surveillance to target activists, government critics, and minority communities. In the past, prominent civil... I'm not going to go all into this because we already know that they've targeted people. The FBI and other federal agencies routinely search through the Section 702 database without a warrant in cases unrelated to national security. As a result, the authority can be used to support government fishing expeditions selectively targeted at certain communities without cause. Exactly. Section 702. Let me read that again. The FBI can go in there and go on a fishing expedition and selectively target a community or anybody, whoever they want to. They don't need a warrant. They don't need a reason. They already have Section 702. That's all they need. They're coming in the name of Section 702. This program is not subject to any meaningful judicial oversight. What do you mean? The Foreign Intelligence Surveillance Court, this is their secret court. They created their own court, basically, which was created decades ago to remedy sordid record of government spying abuses, has no role in reviewing the government's individual targets for Section 702 surveillance. So you understand what they're trying to say. They have no role in reviewing the government's individual targets for Section 702 surveillance. So this is the name of it, Section 702 surveillance. Instead, the court only reviews the broad procedures that the government uses to target foreigners abroad in its effort to minimize the information about Americans that is collected. The process would be akin to a judge signing off on thousands of warrants. So they basically running a kangaroo court up in there doing what they want to do with Section 702. Let's see. The government has deliberately chosen to hide the impact of the program from the public. Oh, say it ain't so. Let's read on. Despite repeating urging from Congress, Congress can't even get through to them, the ACLU and others, the government has refused to release even an estimate of a number of Americans whose communications are swept under the Section 702 surveillance. Likewise, the FBI has not released information about how often they search the Section 702 database for information about Americans anytime they feel like it. Just like I showed you that helicopter flying over my job yesterday. They searching the 702 database, getting information. They want to harass me for posting stuff that's protected under the First Amendment, freedom of speech. Section 702 surveillance chills freedom of speech and associations. What do you mean? The broad, warrantless collection of data under Section 702 creates an understandable fear that private messages may be read or used by the government. This fear creates a chilling effect of anyone using the internet to communicate and has a particularly... let's get to that. So let me get to my suspicious activity reporting. But before I do that, this is a fusion center. Sorry about all that mess. This is a fusion center where they coordinate the exchange of criminal intelligence threats and hazard information, right? So basically over here, they got all these tabs, these blue tabs on my right-hand side: law enforcement reporting, public safety reporting, private sector partner reporting. You can basically submit an anonymous tip or a lead right here. Suspicious activity reporting, SAR, criteria guide. Now let's check it out. Now, this is called criminal activity and potential terrorist threat. You can get flagged, you can get blacklisted, however, put on this watch list if you do this. Breach or attempt intrusion. You could be an unauthorized personnel somewhere attempting to enter a restricted area. If you work at a government facility and you swipe your badge at the wrong keypad, you could get on the list. Misrepresentation, presenting false information or misusing insignia, documents, and or identification to misrepresent one affiliation as a means of concealing possible illegal activity. And this kind of went into how my cousin and them got indicted with misrepresenting false information and documents on those documents, committing mortgage fraud. Theft, loss, or diversion, stealing from a facility, infrastructure that's secured or protected. Sabotage or tampering with infrastructure secured or protected. Cyber attacks, express or implied threats. Communicating a spoken or written threat to commit a crime that will result in death or bodily injury to another person or damage or compromise a facility, infrastructure, or secured protected site. See, that's why this wording is so vague, because when they're talking about communicating a spoken word, that can translate into domestic violence if they really wanted to be petty about it, in which case most of the time they probably are. Aviation activities, learning to operate an aircraft can get you on the list. Potential criminal or non-criminal activity requiring additional information. Now, this right here is for some of you YouTubers, so just check this out. Eliciting information, questioning individuals, or otherwise soliciting information at a level beyond mere curiosity about a public or private event or a particular facet of facilities or buildings. A lot of people, you guys use these amendments to to your detriment when you start digging in all the wrong places and asking all the wrong questions, or even doing all the wrong Google searches. You're eliciting information that you have no business trying to figure out, basically, is what they're trying to tell you. Testing or probing of security, deliberate interactions with or challenges to installation, personnel, or systems that reveal physical, personal, or cybersecurity capabilities in a manner that would arouse suspicion of terrorism or other criminality. Anyways, recruiting, financing, taking pictures or videos of facilities. I've seen a lot of people on these targeted individual platforms that will go to these government facilities, these FBI buildings, stand out there and take pictures and then complain about being harassed. Well, guess what? Right here it says taking pictures or videos of persons, facilities, buildings, or infrastructures in an unusual or whatever that word is. Basically, don't do it, because you could get put on the list, and that's probably why they following you, because you pulling up to the FBI buildings and CIA buildings, taking pictures, challenging the guards, and doing domestic terrorism acts, if you will. Then they're gonna watch you. Demonstrating unusual, prolonged interest in a facility, hanging out, hanging around, seeing what they're doing, you get on the list. Acquiring the wrong material and storing explosive materials, you could get on the list. So anyways, let me go back. You can submit an anonymous tip. You don't have to be a police officer or a government official. You see that? Submit your name, your contact info. An incident happened. That's all it takes to get you on the list. Submit an anonymous tip. Now, I'm gonna leave a link to all of these websites that we discussed. Leave your comments down below. Share my videos if you think this information has been helpful. I appreciate your time. Shalom.